SCOTUS preseason is over, you guys. I hope your Supreme Court fantasy drafts went well this weekend and you are ready to go because it's about to get real. All right, happy Monday, everybody. I'm Bryno, and this is the morning report on the federal courts for October 6th, 2025. Do me a favor. Double tap your screen, comment which justice was your #1 draft pick, and watch the first minute or so, even if you're coming back later, so we can get to the FYP. I'm going to start by catching you up on a couple cases from the last week, then I'm going to give you a quick rundown of the Supreme Court oral arguments going on today. So stick around for those, and you'll know the keywords to listen for, and impress your friends and coworkers with what a smarty pants you are. All right, grab your coffee, buckle up. Day 1 of the fall term starts right now. Coming hot out of the gate with State of Oregon and City of Portland v. Trump. So, a few days ago, Donald Trump federalized the Oregon National Guard and sent them into what he referred to as war-ravaged Portland, Oregon, where he said that federal officers have been viciously attacked by Antifa and radical left anarchists. The problem is that a judge, who was appointed by him, by the way, looking through the actual record on the ground, found that things might not have been quite so dire. In fact, the judge herself stated that, quote, the president's determination was simply untethered to the facts. Now, to be clear, there had been a couple of incidents in Portland, Oregon. There was a fire lit on a barricade and an assault on an officer. The problem is those incidents took place months and months ago, according to the court. In fact, over the latter half of the summer, things have calmed down so much that most protests have been not only peaceful, but included fewer than 20 people. And in Portland, fewer than 20 people at a protest is just brunch. Now, there have been a few complaints since June, but they've mostly been kind of performative in nature, you know, like shining flashlights into ICE vehicle windows and a few other incidents of actually blocking a vehicle, which according to the judge were very quickly handled. So the judge found the president lacked colorable authority to federalize the National Guard. Further, the judge said, quote, because the president is federalizing Oregon National Guard absent constitutional authority, his actions undermine the sovereign interests of Oregon as protected by the 10th Amendment. So, the court issued a temporary restraining order barring the administration's mobilization of the Oregon National Guard until October 18th, which the administration immediately appealed to the Ninth Circuit. But in the meantime, in an attempt to get around the court's order, the president also ordered the California National Guard into Oregon, since the TRO only barred his use of the Oregon National Guard. So last night, Oregon filed a second TRO against use of any National Guard, and last night the judge held an emergency hearing to talk through this one. And very late last night, the judge issued a second TRO enjoining the feds from federalizing any National Guard troops to send into Oregon. So this is going to get interesting fast. I would keep an eye on this, and I will keep you updated. Next up, we have State of New York v. Noem, and this is one could show the beginning of a bigger shift in a series of cases, but I may be getting ahead of myself. We'll see. So to start out, we have to back out a little and talk about Illinois v. FEMA, which I talked about last week. Remember that under the 10th Amendment, the feds cannot make a state enforce federal law. That's not allowed. But there are some ways around that. So, in order to get the states to play along with this administration's new immigration priorities, President Trump is conditioning all of this federal money going to the states on their willingness to help him enforce his new federal immigration policies. And that's like a quarter of the cases we've been talking about so far right now, so this isn't a big surprise probably. But some of these are easier to sell to the public than others, mostly because some of them just aren't that noticeable. Some of them, however, are really hot third rail issues that can really piss people off. And a couple of weeks ago, a case in Illinois overturned FEMA funding being withheld by the states if they didn't comply. And this felt like it might be the sort of thing that would make people mad. Like, messing with disaster funding, that gets messy. But I had no idea how bad this would get, because just a few days after getting the FEMA decision handed down, the administration decided to just full-on put its hand on a hot stove. Like, don't touch, hot touch, hot touch. And they decided that in retribution for New York City not complying with ICE, they were going to cut New York City's terrorism budget. Oof. I mean, okay. So, I'm just going to stop for a sec, let that sink in. New York City's terrorism budget. Well, first, in this case, New York v. Noem, a judge immediately told them to go duck themselves. Citing 9/11, citing all kinds of stuff, the judge said absolutely not. But the thing is, the judge didn't really have to say a thing. See, the state of New York filed this case on Tuesday. The judge issued a scathing restraining order by Wednesday, and by Friday, the public backlash was so bad that President Trump had to withdraw the order, saying that it was his, quote, honor to do so. Okay. I'm sure it was. All right. Okay, now let's check in on today's Supreme Court docket. These are the oral arguments today, which will be at 10 a.m. and 1 p.m. Eastern Time if you want to join in. Let's run through what they'll be talking about. We're going to start with Villareal v. Texas. This is a case where an unaliving suspect was in the middle of being questioned in court when the judge had to stop the proceedings early for the day and call an overnight recess. This was in the middle of his being questioned. Now, normally, this is the dramatic part of the case, right? Where the prosecutor tries to get the defendant to admit something and then slowly get them to admit something contradictory and then yell something and point. But through no fault of the prosecutor and no fault of the defendant, they had to have this overnight recess right in the middle, which could have been a really good opportunity for the defendant's lawyers to take him aside and say, hey, they're laying a trap. You accidentally admitted that you missed the bus that morning and had to walk to work, so your whole bus driver alibi is out the window. Come up with something quick. And so to prevent something like that happening, the judge said that overnight, the defendant could talk to his lawyers, but not about his testimony. They could talk about sentencing or the weather or what happened on Love Island, but not the testimony. And so the question is, we are guaranteed a right to counsel under the Sixth Amendment, a right to talk to our lawyer. So is the judge allowed to say, you're not allowed to talk to your lawyer about this? Even though this was an unusual situation, and under normal circumstances, the defendant wouldn't have had a chance to talk to his lawyer in the middle of questioning like that. So a couple of things to listen for in oral arguments today. In this case, we had an unusually long recess overnight. But one argument is that a long recess may be the exact time a defendant needs their attorney more than ever. This is one of the most important days of this guy's life, and it just turned into 2 days. If nothing else, he probably needs some emotional support. But also, he's not a lawyer, and this may be exactly the time a lawyer should be involved to answer legal questions. The counter-argument is that our whole system is designed to get to the truth, and allowing a lawyer to intervene in the middle here could undermine that. The witness should be testifying based on their memory. There's no need for a lawyer. And so those are the two main arguments, and you can check out oral arguments on that today or listen for those questions to get answered. Okay, second case the court will be hearing today is Berk v. Choy. And this is a case about the Erie Doctrine. And it's one of those cases we all study in law school, and it comes from a 1938 case called Erie Railroad v. Tompkins. I'm going to give you guys the very short version. This case was what's called a diversity jurisdiction case. That means the plaintiff was allowed to bring the case in federal court instead of state court because he was suing a citizen of a different state. Diversity. But we don't like people forum shopping, picking where they want to go sue people to get the best outcome. And one of the ways that we try to prevent forum shopping is by saying, okay, you can bring this state in federal court instead of state court, but that federal court is still going to apply the laws of your state. So whether you brought this in Delaware state court or Delaware federal court, we're still going to apply Delaware law. Except, of course, we're not. That would be way too easy, right? Because the federal courts have the federal rules of civil procedure for a reason, and they have to follow those. So basically, if you bring a state law case in federal court, we're going to apply state laws for any substantive questions, but we're going to use federal law for procedure. Okay, so what's substantive and what's procedural? Aha, that's our question, right? Well, sometimes it's super easy to answer. There might be a rule telling you what font to use. That's definitely going to be procedural. Whether or not to file a proposed order every time you file a motion, 100% procedural. That's going to come from federal law, from the federal rules. On the other side, there might be a law about, say, who is responsible for paying after a mine collapse. That sounds substantive, right? We'll follow state law for that. But it's probably not a huge surprise that somewhere in the middle, what's procedural and what's substantive get a little cloudy. And the Erie Doctrine is this incredibly complicated flowchart that tells us how to figure that out. I'm not going to explain it right now, but I did save a couple of Erie Doctrine flowcharts and a copy of the Erie case in my shared documents in Subject Matter Library under Foundational Cases if you want to go take a look. The point is, Berk v. Choy is a case where they just couldn't decide. So real quick, in Delaware, to prevent frivolous lawsuits against doctors, you have to get an expert witness to sign off on your claim and let the court know it's a real claim, basically. So is that procedural, saying that you have to file an extra form, or is it substantive? I mean, this is a real law with a policy behind it. They were probably trying to cut down on how much doctors were paying for malpractice insurance or something, and it may require a dive into negligence law and medicine and all sorts of substantive local issues. So which is it, procedural or substantive? Well, the district court and the Court of Appeals dismissed the case because the plaintiff didn't get his case certified, and they said this was substantive law, should have followed the state law. The plaintiff says the federal rules of civil procedure have their own rules, like Rule 8, that require you to explain how this is a real claim, and those rules filter out frivolous lawsuits just like the Delaware law. And if there's a federal rule of procedure that basically does the same thing as this Delaware medical expert witness rule, then it must be a rule of procedure. So according to the Erie Doctrine, the plaintiff says the federal rules must apply. So that's the second case that they'll discuss today. That'll be live at 1. You can listen for those discussions. And if you want to check out the flowcharts, so you understand the keywords they'll discuss in the Erie Doctrine, that may make the oral arguments a little easier. So check out my shared documents if you want to see those. All right, that is your Monday morning report for our first day of the fall term, everybody. Woo! Please like, share, comment, all that if you haven't already, and check out the link in my profile to help me keep this running. Otherwise, keep watching, everybody, and I will keep going. Thanks a lot. Have a great day.